From the minutes, item number 1.
Wait, please. Where are we? Very comprehensive. Huh? That's what it is. Very comprehensive. Just got it. Everything. The last report is 26 September.
Yes, sir. We have.
Yeah, which is today.
The other one is 17 days.
Yeah. So this will be the 18th.
Yes, madam. This will be.
So 17th interim report and status report.
Yes.
You have the 17th interim report.
You are 16th. I have up to 16th.
17th is filed on 22nd September.
Yes, sir.
And there's also status report in terms of the previous order.
Yes, sir.
Filed on filed today.
Today morning. Yes, sir.
Let us give them this and then come back middle of next week, and then we'll adjourn it for a fortnight. We'll see what steps have been taken.
Yes, sir.
There appeared to be some restraint on the ground,
Yes, sir.
but not to the extent if the state had cooperated. It's despite the state, not because of the state. And of course, some of the coke oven plants are holidaying abroad, waiting for November to arrive before they come back.
We have already demolished 39 of them. And now direction is also there by Supreme Court not to allow them.
Yes, the Supreme Court order is also there so that they cannot be allowed.
Yes, sir.
And we also hear that there are several applications for scientific mining.
32 of them are there.
In fact, we have done part of your work
Yes, sir.
by exhorting people at
Yes, sir.
SALSA legal awareness camps.
Yes, yes, sir.
Particularly in Clariat, where we were last week,
Yes.
that, give up rat hole mining, form cooperative bodies, and then do it.
Yes, sir.
That's the way to go forward.
In fact,
That's the
we are
message
at the
that
central.
is the message that we thought that it was the executive's job, not our job.
Yes, sir. Now we have received 32 applications together. Out of 32, 17 PL have been approved. In 4 mining plants are likely to be approved anytime, my lord. So then we will be having scientific mining very soon because Central Ministry of Coal has completed the hearing on mining plan and it is likely to pass.
But adhere to all the conditions.
Yes, sir. Lordship.
Particularly the safety conditions.
Yes, sir. Lordship. That will
Because Mr. Advocate,
yes, Lordship.
all of us agree that the people actually indulging in the mining did it out of necessity. And there was a lot of exploitation that went on.
Yes, sir.
They did not make the money.
Intermediary.
They made their 2 ends meet. But it was the other people, the middlemen, who
Intermediary.
made all the money.
Yes, sir.
They were hand to mouth, they are still hand to mouth.
Yes, Lordship is absolutely right.
You must ensure that those people,
Benefits should reach to them.
exactly, that their labor, their hard work, their enterprise, that is rewarded.
And then the kind of risk they take.
Exactly. That they don't take the risks. It was a clear case of exploitation of the people in the state. Most of the others were outsiders.
Yes, sir. Right. Lordship is absolutely right.
Yes.
My lord, I am appearing in item number 3.
Yes.
On 10th of August, this honorable court was pleased to direct state government, my lord,
Yes.
to investigate the matter relating to the other industry, those who are using coal.
Yes.
That have not been touched by my lord, like
Yes.
cement industry.
No,
my
Your
lord.
Lordship, there are three set of industries: ferroalloys, coke oven plant, and Your Lordship, cement industries. Justice Kataki has asked us to carry out the audit. We have carried out the audit. There are discrepancies which have been noticed. Notices have gone to them, and Justice Kataki is monitoring them. My lord, probably it will be part of the report, my lord.
And Dr. Bodhika, what about your land customs authorities? Are they looking into the origin? Because at the end of the day, it was your minister's debtors.
My lord. It appears, my lord, everything is very quiet now at this stage.
No, quiet now is a temporary phase.
My lord.
Because they realize it's a temporary phase. Maybe the Advocate General has asked them to go quiet.
Quiet.
I am already quite.
Like hunkering down to power in the storm talks.
A 17th interim report has been filed in the suo motu proceedings by Justice B.P. Katake, bracket retired. Such report is dated September 22, 2023. Paragraph. In addition, comma, a status report has been filed today by Justice Kataki in pursuance of the previous order of August 29, 2023. Paragraph. On behalf of the state, it is submitted that more than 30 applications have been received for scientific mining, and the applications are being processed, comma, in conjunction with Coal India Limited,
Ministry of Coal.
in conjunction with the Ministry of Coal, full stop. It is hoped that all safety and environmental norms are met while conducting scientific mining, full stop. Paragraph. It is submitted by one of the other petitioners that despite a direction by this court on September 10, 2023,
August 10, your lord.
on August 10, 2023, for the state to look into the other industries using the illegally mined coal in their functioning, comma, no report has been forthcoming from the state, full stop. Learned Advocate General submits that even such aspect of the matter is being monitored by Justice Kataki, and certain anomalies have been noticed by the state in how the ferroalloy industry, the cement industry, and the
coke oven plants.
coke industry obtain their supplies of coal. Full stop. Paragraph. A report in such regard should be filed by the state when the matter appears next week. Full stop. Copies of the 17th interim report and the status report filed today by Justice Kataki may be obtained by all the parties interested from the officer of this court. Full stop. The matter will appear a week hence. Full stop. We'll provide now, or we'll provide then ad hoc payment, because we've been not doing it for a long time. Then, very well. It will appear on 3rd or 4th October.
Please, Your Lordship.
Yes, Mr. Deb, you are appearing for?
I appeared in the second PIL, my lord, item
Yes.
2. Only one, we are filing an affidavit today, Lordship, just to bring, what has happened, Lordship, is this respondent 14 in our PIL, MS Jayama Coal Private Limited, my lord. They had come before, it was our allegation that they are dumping coal in around Goswapara,
Yeah.
and such coal is actually mined in Meghalaya itself.
Yes.
they had in any case come before this honorable court with an affidavit last year itself saying that all the coal that they were in possession of in Baswapara has been disposed of. Now again, my lord, from
You
Justice,
file your no one's stopping you from.
again fresh coal is being seized.
No one's stopping you from filing it. Give an advance copy to them and keep Justice Kataki informed.
Lordship,
Forward a copy to Justice Kataki so that he can ascertain.
Lordship.
And how are you adhering to the schedule? All the previous coal was supposed to
Your
be
Lordship,
disposed of.
total the quantity is 14 lakh and odd lakh metric ton. Out of 14 lakh metric ton, my lord, we have transported 10 lakh metric ton to the pit head of the Coal India report. Now it is with the Coal India, out of which 5 lakh has been auctioned, my lord. 5 lakh.
What about the other coal? How much of other coal have you seized?
Your Lordship, that figure.
Post 2014 coal or post 2016 coal, how much of it have you seized?
Lordship, time to time it has been seized and FIRs have been registered and the auctions have been carried out by pursuant to the order passed by the.
Just correlate the two.
Yes, sir.
You may have, because when they seize, they understate the quantum for obvious reasons. And even that understated amount is not ultimately sold if you add up all that is being auctioned. As we found out in that case, not today, in that Pathar Khama, that police death.
Yes, sir. In 2015.
Marbanian.
Yes, Marbani.
The veritable registers of who gets how much, what is the card,
Yes, sir.
what is the amount. It's a parallel economy running.
Yes, sir. That was there in.
All that was brought to your notice.
Yes, sir. That was there. At 2015 register.
Unless you are sponsoring the parallel economy,
Yes, sir. So that.
you should be taking action in that regard.
Yes, sir. Now we have.
Anything damning? Okay. Let's see what the status report. Page. Yes. Yes, Mr. Nath, you want to say something? You are not audible. You have to unmute yourself. We can't hear you. You are not audible, sir. You are not audible, sir. Unmute yourself.
I'll respond to the affidavit filed by them today, madam. Whatever they are filing, I'll take a copy.
Something wrong with this audio.
We'll hear you on the next day. We'll hear you on the next day and record that we believe that the state of Assam is cooperating in the matter of investigation. So we believe that. So on the next day, please tell us if anything concrete has taken place. Yes, we can barely hear you. Your my lord part is audible. The rest of it is not.
I'll come back. Lordship, I'll inform them.
Very good, very good. Thank you.
Yes, please.
Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
My lord, there are almost 182 markets in the various districts of the Garo Hills, which all belongs to the clans and the Nopas. So I have given the detailed list of those which belongs to which clan. But recently the district council has issued a tender notice for tendering all those markets on behalf of the district council and to collect the revenue therefrom. So we are agreed by the
Who's from the state?
I'm for the district council.
My lord, I appear for the state respondent.
You're for the state.
My lord.
The respondents are who?
I'm for 2, 3, and 4, my lord.
You're for 2, 3, and 4.
Yes, ma'am. State is respondent number 1.
Very well. All the respondents are represented. Affidavit in opposition be filed within 3 weeks. Reply thereto, if any, may be filed within a fortnight thereafter. The petition will appear for hearing 6 weeks.
But in the meantime, the interim prayer is also there.
What is
This tender notice may be stopped, my lord. Otherwise, it will be settled.
Steps taken in the interim will abide by the result of the petition.
My lord.
From the main list, item number 1.
Yes.
May it please your lordship.
Yes.
My lord, here, my lord, the writ appeal is directed against a judgment and order dated 6/6/2017. So we have come with an application for condonation of delay, also of around 2,247 days.
Very good. What is the on merits? What do you have to say?
Right. Well, on merits, my lord, the petitioner here was dismissed from service in the State Bank of India in 2007. Thereafter, my lord, in 2010, he made a claim for payment of the gratuity and the bank's contribution to the Provident Fund. His contribution to the Provident Fund was paid, but the bank's contribution was not paid. So that was refused. I mean, our case before the Honorable Single Judge is that there was no conclusive finding as to any monetary loss having been caused to the bank. And there is
Generally, Mr. Kurti, in these matters, the bank rules provide that if there is termination or if there is severance or if there is premature retirement, then the employer's contribution will not be paid. Was it part of the rules?
Look, a rule was cited by them where the discretion is with the higher authorities of the bank. It was left to the discretion. So it was not an absolute ban.
What was the charge against you?
Charge is that with regard to monetary defalcation. So I may be hurt.
You've been hurt.
Well, I'll take your lordship through that.
Whatever you do, you'll only add to costs. Defalcation by a bank officer and seeking contribution by thing will be punitive.
I'll just pray your lordship to allow me an opportunity to take your lordship through the single judge's judgment.
Carry on. We'll finish it here and now. These things will scotch at the first attempt. No mercy.
Well, I'll take your lordship through the thing.
Yes. Do whatever you have to do.
Annexure 28, madam.
Page?
At page 66/2007. Well, before that, if your lordship would like, I'll take your lordship through the findings in the inquiry, my lord?
No. You bring us to the trial court judge, the writ court judgment, and then if we find that it requires to be interfered with, then we look at something.
Right. So that is 628, page 130.
Oh, this is at page 132.
132.
83, 97, he was promoted officer. And says appropriation.
Well, my lord, our humble submission before your lordship is that all these, what has been reflected in the judgment, my lord, there was no findings to these effect.
We'll give the finding.
My lord, that is what we are agreed by.
We'll give the finding.
My lord, I'll just complete it. I'll take 5 minutes of it.
Yes, please.
But just 5 minutes.
Go ahead.
My lord, our case before your lordship is that the writ court is not an appellate forum against a judgment of the Honorable Single Bench, single judgment. So, my lord, even the Honorable Single Bench is not an appellate forum against the findings of the inquiry.
We are not an appellate forum against the single bench's judgment.
Sorry, my lord, I'm extremely sorry on that.
The writ court does not sit in appeal over a decision by an executive body.
That's
What the writ court does is it goes into the reasonableness of the action. There are 3 things which are to be followed. You tell us if we are wrong. The first is whether there was a fair procedure, whether relevant things were taken into account, and whether due reasons were furnished. These are the 3 which are to see for procedural fairness. Then there used to be previously the Wellsbury principle, which is that whether a prudent man in the person of the decision-making authority could, on those set of facts, taken that decision. If it was a possibility, then the writ court won't interfere. If it's absurd and shocks the conscience of the court, it's only then that the writ court would interfere. That Wellsbury principle has now been replaced by the modern doctrine of proportionality, which is, if you slap me, I can't send you to the gallows. That would be disproportionate to the act complained of. So therefore, that is what it has to. What you say is perfectly justified. In paragraph 11, he quotes the law and he leaves it hanging without doing anything. We'll just supply the reason for it.
What we have tried to...
Because if you come to paragraph 11, you will understand what the... Paragraph 11 says, and the rule which is quoted, rule 24, at paragraph 11, if any member shall be dismissed from the service, so we are not looking into that fact. You have been dismissed, that's attained finality. So you cannot question that anymore. If any member shall be dismissed from the service for any fault or other cause justifying dismissal, it's justified. He shall not be entitled to receive, unless permitted to do so by the trustees, the sums contributed by the bank to his provident fund. Therefore, forfeiture of employer's contribution is the rule.
Malad.
Allowing it is the exception. Now, what are the exceptional reasons for which you should be allowed the employer's contribution? You have not indicated.
Our submission is that, Milan, that there is no finding as to any monetary loss clause to the.
That's neither here nor there. That discretion they have.
Discretion
They have. Once they have the discretion, then again, you would know better that unless the discretion is exercised in a perverse manner, there is no interference.
So, Milord, we are submitting that this discretion, the discretion which is, as far as the Provident Fund is concerned, and as far as the gratuity is concerned,
Statutory bar.
so I'll just take your look.
Statutory bar.
That has been quoted, Milord, in para 10,
Section 4.
Section 4, subsection 6, clause B2. Milord, the gratuity payable to an employee may be wholly or partially forfeited if the services of such employee have been terminated for any act which constitutes an offence involving moral turpitude. So, Milord, in our respectful submission, Milord, there was no finding as to any moral turpitude.
Financial irregularity is the highest kind of moral turpitude. You impersonated another and you lifted. You stole money from the bank. In plain words.
Milord, it so happened, Milord, that there is no such findings as to all that, even in the finding.
There is direct finding, sir. That we couldn't. There is direct finding. You accepted your termination. Yes. Stealing is highest form of moral turpitude.
Milord, only on that, Milord.
You were the bank manager.
Milord, if I can take a lordship to the order of the of the inquiry proceedings, Milord.
Not necessary. Final order of dismissal. Take us to the order of dismissal.
Order of dismissal. Milord. Answer 8, Milord.
Yes. Page.
58.
58. No, that's the inquiry report. Take us to the dismissal order.
Milord, Annexion 9, Milord.
Page 66.
My lord. 66, Milord. Milord. We write with reference to the articles of charges and statements of allegations, video or letter dated so and so, served on you. As you are aware, the departmental inquiry was conducted to inquire into the truth or otherwise of the charges alleged against you. The inquiry authority submitted his report cum findings, a copy of which was sent to you with our letter number so and so. You have not submitted your defense statement against the findings of the inquiry report. The inquiry report cum findings as well as your defense statement against the charge sheet were examined in details. Taking into account all the relevant aspects of the case, it has been decided by the appointing authority that the penalty of dismissal in terms of Rule 67(1) of the rules be inflicted on Sri Pranavishas to meet the ends of justice. The order passed by the appointing authority is enclosed. In case you desire to make an appeal, you may prefer your appeal to the appellate authority within 45 days. Meanwhile, please acknowledge receipt. So this was the order, Milord. After that, Milord, in 2010, he made an application for release of the. Yeah, Milord, another thing which has happened, Milord, even in the
Yes.
As far as the withholding forfeiture of the gratuity is concerned, my lord, there was a fresh proceeding held after that, my lord. Subsequent to this dismissal, when the petitioner here made the appellant here made the claims, my lord, thereafter a fresh proceedings of forfeiture of the gratuity was held, my lord, and he was asked to give a show cause, and he gave a show cause, but after that, without any proper proceedings in the matter, a final finding was given. That is also, my lord, in my...
Where is that?
My lord. My lord, Annexure 16 is the notice, my lord. That is at page 73. And page 80, my lord, is the final findings, my lord.
Where is the writ petition, Mr. Kutis?
My lord, page 85.
Page 85. No, we just want the prayers.
The prayers, my lord. Page 106.
Thank you.
This is our case.
Thank you. There is inordinate delay in preferring in seeking to prefer an appeal in the year 2023 against an order of June 6, 2017, paragraph. However, considering the pandemic in the interregnum and the fact that the appellant feels deprived of dues that he claims are owed to him by his erstwhile employer, the grounds for delay are found to be sufficient for the delay to be condoned and the appeal to be taken up for consideration on merits. Full stop. Paragraph. The appellant was an employee of the State Bank of India. During the period that the appellant was posted as the branch manager at Songsak branch of State Bank, between June 11, 2004 and March 19, 2005, it is alleged that he committed gross irregularities in issue and payment of deposits and in advances, full stop. Full stop. The employer instituted disciplinary proceedings on account of defalcation, irregularities, and non-adherence to the bank's rules. Full stop. It is not necessary to go into these specific charges or the findings rendered by the inquiry officer full stop. All that needs to be noticed is that by an order dated August 8, 2007, the appellant was dismissed in terms of Rule 67(J) of the SBIOSR, which appears to be a set of rules applicable to senior officers of such banks, of the bank, full stop. During the period of the disciplinary proceedings, the appellant was under suspension. Paragraph. The order passed in the disciplinary proceedings has attained finality and, indeed, the appellant has made no attempt to reopen the case, full stop. Several years after the appellant stood dismissed from the bank service in the circumstances indicated above, he made a claim for the employer's part of the contribution towards Provident Fund and the gratuity to be released to him. Full stop. Paragraph. As to the employer's part of the contribution to the Provident Fund, comma, the bank denied the claim by referring to Rule 24 of the SBI Employees Provident Fund Rules, which provides as follows, colon, set out from impugned judgment. Full stop. In respect of the gratuity, comma, the bank issued a letter on March 27, 2012 for the appellant herein to show cause why the gratuity due to him should not be, gratuity otherwise due to the appellant should not be forfeited. The appellant responded to such notice and indicated that nothing in the inquiry report on which the appellant's order of dismissal was based indicated that any pecuniary loss had been occasioned to the bank by reason of the acts complained against, by reason of the appellant's acts complained against. Full stop. However, comma, by a terse order of May 2, 2012, the appellant's plea for gratuity was rejected and the entirety of the gratuity was directed to stand forfeited. Full stop. Paragraph. The writ petition came to be instituted in the year 2013 with the two principal reliefs being for the employer to release the gratuity due to the petitioner and due to the appellant, and also the employer's contribution towards Provident Fund. Full stop. In the judgment and order impugned of June 6, 2017, comma, the second paragraph captured, comma, in a sense, comma, the claim in the petition before the third to the sixth paragraphs narrate the circumstances in which the appellant came to be dismissed from service. Full stop. After noticing the extent of claims on account of gratuity and the Provident Fund contribution of the employer, comma, Section 46BII of the Payment of Gratuity Act is quoted at the foot of paragraph 10 of the impugned judgment, and Rule 24 of the aforesaid Provident Fund rules of the State Bank are quoted at the foot of paragraph 11 of the impugned judgment, with the following as the concluding paragraph thereof, open quote 12. With this observation and direction, the writ petition is dismissed and stands disposed of. Full stop, close quote. The appellant is understandably aggrieved since, according to the appellant, the relevant provisions have only been quoted and no reasons have been indicated in the impugned judgment as to why the petitioner, the appellant herein, was disentitled from receiving the gratuity, or why the entirety of the Provident Fund contributed by the employer could have been forfeited. Full stop. Paragraph. It is evident that from the relevant clause of the Act of 1972 that a discretion is conferred on the employer, as would be evident from the use of the expression, open quote, may be wholly or partially forfeited, and the circumstances justifying forfeiture have been indicated thereafter in the statute. Full stop. There can be no dispute that this was a case of gross moral turpitude in a bank manager having encashed deposits apparently made by customers of the bank full stop. It was a charge of defalcation which was conclusively proved. Full stop. The appellant has accepted the finding and the decision has attained finality. Full stop. Paragraph. Since the bank in this case, as the employer, was entitled, in terms of the statute, to partially or fully forfeit the quantum of gratuity, as the appellant had been found guilty of an offence involving moral turpitude, an exceptional case had to be made out by the appellant for the bank to partially or fully release the gratuity that would otherwise have been payable upon the appellant's successful completion of his tenure and attaining superannuation. Full stop. No exceptional reasons were cited by the appellant in making the appeal. Full stop. On the contrary, the appellant, despite as a matter of right that he was entitled to the gratuity. Full stop. Paragraph. It is possible in an exceptional case that an employee, comma, in dire circumstances and in distress, comma, is forced to commit a wrong, semicolon, whereupon the employee expresses remorse, cites the circumstances, and seeks pardon and makes a plea for the financial benefit to be released by citing extraordinary circumstances or dire distress. Full stop. This was not such a case. Full stop. An officer of a bank in the position of the branch manager had been found guilty of stealing, comma, no less, semicolon, and he appeared to stamp his foot and demand his dues. Full stop. Such employees have to be dealt with ruthlessly. Full stop. Paragraph. No ground was made out by the petitioner for the bank to exercise any discretion in his favor to release his gratuity or any part thereof. Full stop. As to the Provident Fund, comma, Rule 24 of the relevant rules indicate that upon the dismissal or the like of an employee from service, the general rule would be that the employer's contribution towards the Provident Fund of such employee would stand forfeited, semicolon. But the relevant board also had, but the relevant trustees also exercise an element of discretion as to whether the employer's contribution may still be made available to the dismissed employee. Full stop. In the manner that the relevant rule has been framed, comma, where forfeiture is the rule and payment is the exception, comma, a case has to be made out therefore. Full stop. It was open to the appellant, comma, if the circumstances so existed, comma, to make out an exceptional case of financial hardship or distress in some other form that may have prompted the bank to exercise its discretion in favor of the appellant despite his proven guilt and his dismissal from service. Full stop. The appellant's appeal to the bank was not on such lines. The appellant asserted a right, comma, which the appellant did not possess. Full stop. Paragraph. It was obvious from the tenor of the impugned judgment that the mere reiteration, that the mere iteration of the applicable rules would suffice. Full stop. However, comma, the writ court may have done well to add a few sentences to justify the conduct of the bank. Full stop. As the appellant, as is appropriately submitted on behalf of the appellant, comma, a writ court does not sit in appeal over the order passed by an executive functionary which is challenged in proceedings under Article 226 of the Constitution, full stop. Ordinarily, comma, the writ court is concerned not with the correctness of the impugned order, comma, but more with the decision-making process, full stop. Once the writ court finds that a fair procedure was adopted and the complaining writ petitioner was afforded an opportunity to make his representation, which was, comma, thereupon, comma, taken into consideration before the impugned order was passed, comma, the writ court would not interfere. Full stop. There are obvious exceptions in cases where the order impugned is found to be grossly disproportionate or so absurd that no meanest mind in the position of the executive functionary could have passed the same on the set of facts presented before it. Full stop. Paragraph. In this case, comma, the discretion of the bank in either case cannot be said to have been perversely exercised. Full stop. Here was a disgraced bank official who was shamelessly pursuing demands for payment as if they were a right. Full stop. There was no such right in favor of the petitioner, and the bank, comma, particularly as a nationalized bank, has done well to exercise its discretion against a recalcitrant employee, erstwhile employee. Full stop. Paragraph. There is no merit in the appeal, just as there was no meaning or good reason for the writ petition to have been carried to this court. Full stop. For all of the writ petitioner's efforts, comma, the writ petitioner will pay cost assessed at rupees 25,000 to the bank within a fortnight from date, comma, failing which the bank will be entitled to execute it in accordance with law. Paragraph. Appeal number so and so is dismissed. As indicated, the miscellaneous application is allowed. Urgent certified website copy. Yes.
Item number 2.
Thank you, sir.
But the notice is not complete in this matter, my lord. Well, I'm praying for a little longer time, my lord.
Very well. Since service has not been completed, effected yet, comma, let the matter appear 4 weeks. An affidavit of service should be filed. Yes.
Item number 3.
May I please your lordship?
Yes,
Lordship,
madam.
Lordship, the matter was barred by limitation and I was exempted in it. Still, Lordship, the adjudication order has been passed. Lordship, it was proposed by your Lordship that we may go to regular remedy, Lordship, of filing an appeal under Section 85. Lordship,
Yes.
we are accepting your Lordship, the proposal that we will go to an appeal. Only thing is that Lordship, it was an ex parte Lordship,
Whatever it
citizen
is.
demand, which is an so Lordship, my only that if I may file the appeal within 1 month, Lordship, my delay.
We cannot. We have no authority in that regard. It is evident that previous orders in this matter noticed that the petitioners had an alternative efficacious remedy available. Full stop. Paragraph, the petitioners now seek to avail of the regular remedy and make a prayer for the delay in approaching the regular forum to be condoned. Full stop. Paragraph, since this court does not exercise the authority to condone the delay before another forum, comma, it is only observed that if the regular appeal is preferred within 7 days from today, comma, the concerned forum may take a sympathetic view of the matter. Full stop. Paragraph. Accordingly, comma, WPC number 63 of 2023 is dismissed as not pressed and without going into the merits thereof. Full stop. There will be no orders to cause. Yes.
Item number 4.
Lord, the appellant was aggrieved by the placing of her name in the gradation list.
Yes.
Below those who were appointed after her appointment, 2-3 months after her appointment.
Sorry, didn't follow you, Mr. Vicky.
The gradation list was prepared by lot in which the appellant's name came below the name of those
who had been appointed after him.
Yes, my lord. This is the case.
And the writ court dismissed the petition.
Yes, my lord.
On what ground?
My lord, please come to page 194, last page of the
194.
Yes, my lord. Paragraph 12. It says, my lord, though it has been reiterated and held in various judgment that the date of entry into service is the safest route to follow while determining the interstate seniority between one employee or the other. However, in circumstances such as the present case, where there is in presence of rules framed under Article 309 of the Constitution, which creates a distinction as provided in Rule 29(1)(b), the contention that the respondent number 5.
What is Rule 29(1)(b)?
It says that as per the merit list, the name should be in the gradation list as per the merit list.
Is it the same process?
No, my lord.
Different process?
Different process.
How can the name be in the same?
Yes.
How can different processes have the same merit list?
Yes.
Yes, Mr. Khan?
Worship is the same process.
This is the same process.
Worship,
But we are having an integrated process. A has joined, A is placed number 4 over there, B is placed number 6.
Worship, yes.
A joins 2 days before, B joins 3 days before A, does not matter. According to merit, they will be placed.
Absolutely.
This is not the case, my lord.
Lordship,
They were appointed.
let him submit. I'll come.
Yes.
I'll come.
Yes.
They were appointed after that only, as per their own list
What
provided.
are the dates of appointment? Bring us to the 2 appointment letters.
Appointment letters. No, as per annexure in the affidavit filed by them,
Lordship, if I just take a lordship to page 111. Merit list prepared by MPSC.
Yes.
Lordship, 21, serial number 21 is respond number 5. 22 is respond number 6.
Respond number?
5.
5.
this is 5, 6, and 7.
22 is respond number 6. 23 is respond number 7.
Yes.
Lordship will come to the last part of the table. And
Yes.
this is the merit list. Prepared by MPSC.
Yes. Where is the petitioner?
Petitioner is a 23.
Petitioner is 23.
24.
24.
68.
So therefore 22 is 5, 21 is 6, 23 is 4.
4.
Petitioner is 24.
24 is petitioner, Lordship.
Yes.
But you will see in the ranks, petitioner is 68. Respond number 7 is 58. 6 is 55. R5 is 53.
Yes.
So this was a merit list, Your Lordship. They are part of the same cadre.
Yes.
And they are all direct recruits.
Yes.
So this is the factual situation, Your Lordship.
Yes.
And now if you come to the rules.
No, nothing else necessary. Now you directly come to page 72.
Your Lordship.
And that is the gradation list.
Yes, ma'am.
In the gradation list, let us show the same number of names. Petitioner is K.T. Sangma,
24.
M.L. Sumal, Y. Sungta, and Nong Si.
They were above me.
All above you.
Yes, madam. As per the gradation list.
As per gradation list, yes.
But my lord,
Might be then date of birth, then date of first appointment into service.
that is material, my lord, date of appointment.
Appointment into service, yes.
So it says 21 is 497 and then 597 12406.
That's neither here nor there. Neither here nor there.
Lordship, one more aspect of the matter, Lordship. Lordship, if I may take a Lordship to, can you come to Lordship page 77?
Page 77.
Yes, Lordship. It starts from page 76. This is the letter 9th November 2020. But petitioner has written this letter.
Where? Page?
Page 76 is the letter.
Yes.
9th
To the
November.
director. Yes, the petitioner's letter.
Lordship.
He quotes Rule 29(1)(b.
Lordship is.
Yes.
And Lordship, he quotes Rule 27, and then Lordship will come to page 77.
Yeah, on provision
On provision.
made senior to me as they fall under Rule 29, which I am not pressing upon, as the name appears to have in the mind in respect of lingua. Oh, he had given up.
Lordship. Look, I'm just coming to. I'm coming.
Point of time.
Lordship, let me clarify.
At that point of time, they were not the parties here. It is only thereafter they were made a party. Independence party. This 5, 6, and 7.
Yes.
Lordship, allow me to
Yes, lingua.
No, my first grievance was against the person who later on he took voluntary retirement.
Okay.
And then
he was lingua.
he was
lingua.
RK.
He is lingua.
Lordship, let me just clarify, Lordship. Just confusion of facts. The writ petition was filed basically challenging lingua, who was R4. And during the pendency of the R4 voluntarily retired, and they did not press. That is observed in the judgment in detail, Lordship.
Very good.
So far, present.
So they implemented the others.
After that. After
They implemented the others.
yes.
Lordship. And then, Lordship, this was the stand
Where was lingua in the gradation list?
Above me.
above.
And at page 111, where is lingua?
And Lordship, let me clarify, lingua did not come from the direct recruitment route.
Oh,
He was a promotee.
he was a promotee.
There's a distinction in Lordship between promotee and direct recruit. 5, 6, 7 are direct recruit.
Yes.
And it is the admitted case that he has no grievance because they admit that the 5, 6, 7 are part of the route.
Yes, that's all right. Yes, understood. Yes, sir.
So my submission is that Mr. Lingua first was made a party. Actually, he should have been
Lingua is over. Lingua is dead and gone.
Yes,
Lingua is
then
over.
we had to make 4, 5, 6, and 7 as a party because they were not implemented. It is the government said that now they will come in picture.
Nothing.
But they were, my lord, appointed after me.
Waste of time. Waste of time.
But it is not that from the same appointment process they were appointed.
Please come to page 111. It's the same notification dated 6th of July or something like that. 6th of December 2006. MPSC period number, all of them are the same examination.
Examination is same, my lord.
If
But
it is the same examination, how will it differ?
they were appointed differently.
They were not appointed differently. They joined their different dates.
No, my lord, they were appointed on different dates.
Even if they are appointed on different dates, it does not matter. Our judgment in our judicial officer's case is binding on this aspect. What is it called? That the judicial officer's case where we have direct recruits and things now. Mazhar Malik Sultan. absolute authority on that proposition.
But that should be considered when they have come and joined.
If you want to waste time, go on wasting, like the previous matter. This appeal is utterly unmeritorious and a complete waste of time. The grievance of the petitioner, of the appellant, pertains to a gradation list in which the names of certain colleagues of the petitioner, all placed in the same post, were indicated ahead of the petitioner. Full stop. Paragraph. According to the appellant, a gradation list has to be prepared according to seniority, and since it is the admitted position that the petitioner, that the appellant joined service ahead of the respondent numbers, who are over here?
5, 6, 7.
5, 6, and 7, the name of the appellant should have been higher on the gradation list as compared to the names of the said private respondents. Full stop. Ordinarily, when recruitment is conducted through a competitive process, the persons who gain appointment at the end of the process are graded according to the merits. Are graded according to merit. Full stop. In other words, persons who obtain higher marks in the relevant competitive examination are placed higher in the gradation list when as against persons who obtain lower marks. Full stop. In many cases, erroneously, the gradation list is mixed up with the reservation list. Full stop. While the reservation list indicates how many of the recruits at a particular recruitment process would have to fall from among the reserved categories, the gradation list prepared at the end of such recruitment process has no nexus with the roster and has to be prepared according to the inter se merit based on the marks of the candidates at the particular process. Paragraph. In this case, there is a clear rule in terms of Rule 29, 1C, 1B, that provides that inter se seniority of lower division assistants would be in the order in which their names appeared in the result of the competitive examination conducted by the Public Service Commission. Full stop. There can be no dispute that both the appellant and the respondent numbers 5 to 7 participated in the same competitive examination and recruitment process, which was initiated by a notice dated December 6, 2006. Full stop. Indeed, in the memorandum issued by the state dated November 17, 2020, fixing the inter se seniority of employees of lower division assistants in the Directorate of Commerce and Industries, 6 names were indicated. Full stop. The first name belonged to a promotee. Full stop. The next 3 names belong to the respondent numbers 5 to 7 herein.
Yes.
The fifth name was that of the appellant, and the 6th name was that of another. Full stop. As far as the person first named in the seniority list, there could have been no dispute since such person was a promotee and not a direct recruit selected upon the competitive examination being completed. Full stop. Indeed, the writ petition was instituted by the appellant against such promotee and complaining of the name of the promotee appearing ahead of the appellants in the gradation list. Full stop. However, during the pendency of the writ petition, the relevant promotee attained superannuation, and the writ petition was subsequently amended to include a challenge against the respondent numbers 5 to 7 herein. Full stop. Paragraph. It is plain to see from the interstate seniority list of November 17, 2020, that while the petitioners, while the appellant herein ranked 68th in the merit list, the 3 private respondents ranked 58th, 55th and 53rd in the same merit list. Full stop. Since it is also evident that the merit list pertain to the same recruitment process, irrespective of when any individual actually joined the service, the seniority and gradation list would depend on the merit, would depend on the marks obtained in the recruitment process and the position on the merit list. Full stop. Indeed, the appellant herein has no case at all. Full stop. On November 9, 2020, the appellant complained to the Director of Commerce and Industries that certain anomalies in the gradation and seniority list ought to be corrected. Full stop. In the relevant letter, the appellant quoted Rule 29(1) (1) of the relevant rules, and towards the end of the letter, in the final paragraph, this to say, next line, open quote, on perusal of the R capital rules quoted herein above, it is clear that serial numbers 21, 22 and 23 is made senior to me as they fall under Rule 29(1) which I am not pressing upon, as their name appears to be above me in the merit list conducted by the MPSC, but in respect of Shri G.S. Lingua, serial number 20, who is the promotee from typists, ... Close quote. The persons whose names appeared in serial numbers 21, 22 and 23 are the respondent numbers 5 to 7 herein. Full stop. It is evident that the petitioner understood the exact meaning and purport of Rule 29 bracket 1 bracket B and abandoned in writing his challenge to the placing of such persons ahead of him in the seniority and gradation list. Full stop. In such circumstances, comma, upon Lingwa's retirement, comma, there was no cause for the writ petitioner for the appellant to pursue the writ petition, and no justification or basis to flog the dead horse by impleading the respondent numbers 5 to 7, full stop. The petitioner had clearly admitted much earlier that the respondent numbers 5 to 7, comma, on the basis of Rule 29 bracket 1 bracket B of the said rules, comma, were entitled to be placed ahead of the petitioner in the seniority cum gradation list. Full stop. Paragraph. In such circumstances, comma, since the trial court, since the writ court has referred to the relevant rule and justified the gradation list on such basis, comma, there does not appear to be any error committed or any room for interference therein in appeal, full stop. The appellant, comma, is evident, comma, merely attempted to take a chance both before the writ court and by filing this utterly specious appeal, full stop, paragraph. As a consequence, comma, appeal number so-and-so is dismissed with costs assessed at rupees 25,000, which should be paid by the appellant to the state within a fortnight from date, full stop. A message should go down loud and clear that exhibitionists and adventurers like the appellant have no place before a court of law or to invoke any discretion under Article 226 of the Constitution. Full stop.
Being a clerk, 25,000
Sir?
would be reduced.
25 is less. If I were in Calcutta, these would be 6 figures.
Item number 5.
শুধু এই বললো তার এগেন্সটে কেস নেই, তারপরে সে অ্যাপিল করে দিল। He on the council is appearing. You're hearing it for the first time. Yes. You have to begin because my brother is hearing it for the first time.
Well,
We'll keep it on 3rd October, 3rd, 4th, whatever you type, take, and immediately after you finish, we'll dictate, because the only point is that you have not complied with 48 or 50. 42. Not complied with 42. If you've not complied with, then law has taken its own course and the trial court has given adequate reasons. All right? That's because the other judgment from yesterday, I have to correct it now.
well, on 3rd.
On 3rd. But please make yourself convenient. If it is not convenient on 3rd, tell us, we'll do it now.
As of now, my lord, I don't think there is a problem.
Because the facts and everything have to be indicated afresh. You know, I can't take it for granted because I've heard.
Well,
It has to be heard out again. Yes.
Item number 6.
May we please, Your Lordship?
Yes.
Your Lordship, the conducting counsel, my senior's health is still down, Your Lordship. I beg to seek for further adjournment.
Mr. Mantha,
Yes, Your Lordship.
continuous. I
Lordship.
told you last time.
Yes,
that
Your Lordship, Your Lordship. I beg 3 weeks' time, Your Lordship.
2021. It is hoped that some alternative would be made. There are orders to that effect. These orders are not passed just for fun.
Yes, Your Lordship.
Come back tomorrow.
Your Lordship.
Come back tomorrow and move the matter. No. This can't be allowed.
Lordship, if 2 weeks' time can be.
No, 2 weeks. This can't be allowed.
But is
Tomorrow. Sufficient time has been afforded to the appellant to make alternative arrangements. Full stop. And there must be an end to the court's patience. There is an end to the court's patience. And the appellant cannot seek to embarrass the court any further. Full stop. The matter will appear tomorrow. Not tomorrow, give the date. What is this? POXO?
Lordship, legal issue, Lordship, the magistrate was not examined.
Legal issue?
Madi gun.
Oh,
that is it.
Oblige, Your Lordship.